Good morning. Welcome to a meeting of the California Paraprofessional Program Working Group. I can begin by taking roll. Bashan?
Here.
Reynolson?
Here.
Falmouth?
Here.
Fleischman?
Here.
Judge Harper?
Here.
Hartston?
Here.
Kirkmeyer?
Here.
McRae?
Here.
Olvera?
Here.
Justice Petru?
Here.
Robinson?
Here.
Judge Rubin?
Here.
Shining?
Here.
Sarouche?
Here.
Spiro?
Here.
Torres Umbriz? Judge Wiley?
Here.
And as we said, Stephen Hamilton and Judge Yu are expected to join us a little later. So we have a quorum. We have great
All right,
attendance.
then.
Thank you, everyone.
Thank you, everyone. Happy Friday, everyone. Even happier Friday when we get through all of our agenda today and get everything done. So let's start with, I see one person who I see on here on the attendees with their virtual hand raised. If anyone else who is attending would like to make comment, if you could please raise your virtual hand, I would appreciate that. Okay, I don't see any other hands. Oh, and now I see, okay. I see a couple. Linda, why don't we go ahead? 3 minutes, please.
Okay.
And if we could please start with Mr. Tellieu, since he had his hand up first.
Yes, Olivia Tellieu.
Good morning. Can you hear me?
Yes.
Good morning, members of the committee. Relating to the fee sharing, the committee voted down modifications to Rule 1.5.1, which allowed for the sharing of fees among paraprofessionals and lawyers not at the same firm, yet voted yes on allowing the sharing of fees if they are in the same firm. This is a distinction without a difference. The forming of a, quote, law firm is an amorphous distinction that can be achieved with a simple filing. I can start a law firm tomorrow, separate from my current practice, and grant 49% to a paraprofessional. That paraprofessional can then actively seek referrals, either by way of their relationship in the community or by soft or actual capping, which is incredibly difficult to regulate, and share in the fees associated with the case. This modification would unleash hundreds of unscrupulous individuals to the undeserved communities to get the highest value cases, as all firms would have to engage in this practice to remain competitive. Thus, the notion that a paraprofessional should be allowed to share fees in non-allowed areas of practice needs to be eliminated for the good of the public. As it relates to fee caps and percentages contingencies, the committee's proposal does not cap hourly fees, yet allows contingency fees. This turns the justice gap on its head by making paraprofessional fees potentially outside of the reach of the most needy and by providing less equality representation for contingency matters. Nearly every area of the law worth charging contingency fees is being currently serviced by hundreds, if not thousands, of law firms. If there is a way to achieve a sufficient recovery on contingency, either because the claim is worth pursuing and the defendant has means to pay for it, there is no access to justice issues, as attorneys are available even for small matters. But ironically, paraprofessionals will be allowed to charge as much as they want to provide services which more often than not would need to be provided for free to bridge the justice gap. This provision encourages unreasonable, upfront, flat, or other types of fees that disproportionately affect the most vulnerable communities. I encourage the committee to vote no on both of these measures. Thank you for your time.
Thank you. Lawrence Knapp.
Can you hear me?
Yes.
Good morning. Thank you. I want to make the point that in my view, alternative solutions have not been adequately explored. A key threshold issue has never been adequately addressed by the committee and those pushing these proposals. Why set up an entirely new for-profit business structure with these paraprofessionals who may do real harm to people when the state bar has not adequately considered alternative proposals within their existing authority? They're already attorneys licensed and ready to help consumers in many of the areas identified in the Justice Gap study. Consumers need greater access to free legal services and contingency fees attorneys. Unfortunately, the state bar has created the hurdles for more attorneys to practice law in California. Why not address these hurdles before creating a whole new cottage industry of paraprofessionals? Why not do a good job at ensuring we have adequate numbers of attorneys able to meet this justice gap? The state bar has chosen to limit the availability of attorneys and made their degrees incredibly difficult to obtain and costly. We should encourage reciprocity and lower bar cut score that would mean the state bar is actually doing its job. We should also encourage those who want to do legal aid work by funding their organizations and helping them with student loan debt forgiveness so they won't leave those positions. I would urge the committee to vote no.
Thank you. Jason Solomon.
Hi, this is Jason Solomon, Stanford Center on the Legal Profession. I will be very brief. I just want to say I think this is a terrific proposal, and I want to thank all of you for all your work on it. There are a few things in there that I might disagree with or might change, and I'm sure you have already and may continue to hear your share of negative comments today. But this is such an important step forward for the legal profession and for the legal services market. And I just want to make one substantive point, and that is other people who have criticized and will criticize this proposal talk about the risk of consumer harm. The risk of consumer harm is comparative. It has to be evaluated in a comparative way. It's what is the risk of consumer harm if this proposal is enacted or something like it, and what is the risk of harm under the status quo? The risk of harm under the status quo is 100%. It's not a risk. We know that under the status quo, consumers are being harmed every day by not having access to affordable legal services on critical issues that affect their lives. This will improve that and make the risk of consumer harm much less. That is one reason why it's a terrific proposal. Thank you very much. And again, thank you for all your work on it. I hope you feel good about putting this terrific proposal before the board, and I look forward to advocating for its adoption before the board as well.
Thank you.
All right.
Kip Miller. Oh,
All right. So I do not see any other hands raised. Is that correct, Linda?
yes, there is Kip
Oh, now-
Miller.
Yeah, Kip just came back in. So let's see.
Hi, can you hear me?
Yes.
Sorry about that. I'm on the road, but so I'll keep it brief just in case. My name's Kip Muller. I'm not speaking on behalf of LACMA's Access to Justice Committee, but I am on it, and I only say that to say I am very concerned about access to justice in California, and I don't believe this is the correct solution. The same corporations that are likely to get involved in this cottage industry that was mentioned by a previous caller or speaker, I don't see them lobbying for a lot more funding for pro bono legal services, which I do quite a bit of, for nonprofits that provide legal services that would bridge this gap. And I agree that there are alternative solutions, such as allowing more attorneys, but this is a very professional, this is a professionalized industry, and it's important not to cheapen the practice of law or corporatize it and bring in incentives that may disrupt the duty of loyalty we have to our clients. So this and believe that there are alternative solutions that are much better, that are available and should be explored before something as drastic as this.
All right. Thank you to you as well. I see one more hand.
Jennifer Ostertag.
Good morning. Thank you for your time. I echo what Olivier Tallieu and others have said about the risk of creating a new for-profit profession instead of funding more legal aids and actually giving free legal service to people who need it. But my main point this morning is to encourage you to vote the proposed amendment to Rule 5.4, which is currently allowing paraprofessional to have a non-majority ownership in the law practice, that both lawyers and paraprofessional, and in a firm that has a practice area in which the paraprofessional is not licensed. Having anybody who has first a minority ownership is vague. That means up to 49%. And having anyone who can own 49% of a company makes the decision for the firm. It will influence which cases the firm is going to take. It will influence salaries and who is hired as a lawyer. I mean, it will interfere with an attorney ability to fiduciary duty to its client. So I really caution you on this rule, and I don't think the rules of professional conduct should be watered down. They need to be stepped up. We have seen and allowing paraprofessional to be sharing fees and owning law firms essentially is inviting a lot of bad actors to take advantage of consumers. Thank you very much for your time.
Thank you. All right, I do not see any additional hands. And speaking of Rule 5.4, unless Leah or Linda tells me otherwise, I think we're going into discussion on that. Is that correct?
Yes.
Okay. Do we have a slide or anything, or is it just, how are we handling this?
I was gonna just share the rule on my screen so we can discuss it. I think that Stephen looks like he has his hand raised and might want to lead the discussion.
Justice Petro, I was
Yes,
going to make
Stephen.
the motion and Steve
Sure.
Hamilton was going to second it. I know he has strong views on the matter. Last time the vote was 8-8. I defer to you how you want to handle it if you want to go next.
Yeah, so do you have any idea when Stephen Hamilton will be joining us?
I do not.
Linda, do you have any idea?
He said he had a hearing this morning and maybe it was, I think he said maybe around 11.
Yeah, we can't. I mean, the problem is that this is really our one substantive thing before doing the review. So unless, I was about to say Stephen Fleischman, but we know who we're talking to since it's only one Stephen right now. So Stephen, unless you have a strong feeling about this, I think we should probably go ahead.
That's fine. We've debated this a lot. I don't want to go over points. I just want to add 2 points.
Sure.
Number one, last time someone said this vote does not involve technology companies or investment banks taking over law firms. And I respectfully disagree with that. Right now, there is a hard and fast rule that only lawyers can own law firms. This is the first step in what I think is an agenda by large corporations and investment banks and technology companies to try to get into the legal marketplace, which I don't think is good for consumers or for the profession. And so, in Vietnam, there was a phrase, salami tactics. First, we allow paraprofessionals to own law firms. Then we allow technology companies to own law firms. Then we allow chiropractors to own law firms. Then we allow investment banks, et cetera. This is a slippery slope. I'm not in favor of it. Number two, when this goes to the legislature, it will be extremely controversial. I can guarantee you of that, and Steve Hamilton, if he were here, would agree with that. The problem with this particular rule is this rule will be adopted by the Supreme Court, not by the legislature. What that means in practical terms is if you are a member of the legislature and you are opposed to this, your remedy is to kill the entire program because you're not going to be able to regulate the rules of professional conduct because that is in the Supreme Court's purview. So, we have spent a year and a half on this program. I would hate to see the whole program die because of a provision that even the proponents acknowledge is not necessary for the program and, is a wobbler at best. Thank you.
Okay. Let's see, who shall we go to next? Dana?
Thank you. I am wondering if we could, Stephen, is your motion to simply re-vote and try to vote no, or is
Yeah,
there?
and thank you, Dana, because my brain didn't function properly, because before moving on to anyone else, I should have gotten clarity. And so Stephen, if you could please state your motion, and then we'll see if we have a second.
My motion would be to reconsider the vote where we allowed non-lawyer ownership of law firms for paraprofessionals to own it. The way
In
this
other
was
words,
set up,
excuse me, in other words, just take a new vote on this.
yes, the way this was set up, there was an initial vote. Should we allow paraprofessionals to own law firms, yes or no? That carried 9-5, I believe, with 2 abstentions. I'm moving for reconsideration on that. If the answer to that is no, I think, and Greg can correct me, it'll be pretty easy to fix the language in 5.4.
Okay, so just to be clear, we had a conversation last time where I had to decide whether to put this on the agenda today. And based on that discussion, I decided, yes, we were putting it on. So it's my understanding, Leah can correct me. People who are better with procedure can correct me, but it's my understanding that at this point, we're not deciding whether to reconsider it. That decision has been made and it's being reconsidered. And right now what you are doing is moving to have a new vote on 5.4.
Yes.
Brady?
I think actually because we couldn't have a vote and it was just at the last meeting, your decision to put this issue on.
Yeah.
We need a motion for reconsideration.
So let's start with that.
Before we have a reconsideration vote.
Okay, so let's do that. Let's do one step at a time. Stephen has moved for reconsideration. Is there a second?
This is Sharon.
Hi, Sharon. So Sharon has seconded that. Why don't you go, do we need to have discussion about that? People have their hands up. Is it about whether to reconsider? Dana saying no. Ira?
Yeah, can we state explicitly what it is that we'll be reconsidering?
We would be, what we are deciding is whether or not we are taking a new vote on Rule 5.4. And so if the motion for reconsideration carries, we will then have further discussion, of course, and then take a vote on Rule 5.4.
Well, more specifically, this is what I'm getting at. What, the whole rule or a vote on, the second vote would be on some difference in the rule. So in other words, a variation of the rule. We're not going to get rid of the whole rule, I don't think.
Your Honor, if I may, I believe you're looking at 5.4E, right?
Stephen?
Yes.
It's your motion.
Yes.
All right.
Okay, so
5.4E.
all right, so Linda, for the motion, Stephen, if I'm understanding correctly, the motion is for reconsideration of 5.4E, and Sharon, you agree with that, is that correct?
Yes.
With that.
Okay. All right, so with that, Carolyn, do you have a comment about whether to reconsider or
Yes,
should I?
yes, 3 things, Your Honor. First of all, could Linda put up the actual red line version so we can see more specifically what we actually voted to amend? Thank you. And then I don't understand the procedure because I thought that we voted on this, which is why we're even talking about it at all. So I don't understand, and maybe someone can clarify for me going back into the notes or whatever. I don't know how we could talk about this at all if we didn't already vote to reconsider. So I don't understand that. That's a question. And then the third thing is I feel very strongly that we should wait for Steve Hamilton, Judge Yu, and Claudia Torres. We're here all day. If they assume that we were going to have a lot of public comment or whatever, if they, there are a lot of us who are working court professionals. And so if a motion came up for Steve and a motion came up for Judge Yu, I think that it's really important because we're talking about the law. Let's give them some time to get here by 11. It's 10:23, that's 40 minutes. I know Steve was a He seconded this motion to talk about this. And I think Claudia voted to reconsider this. I don't know, I can't remember if Judge Yu was here. But I think it's really important for the sake of the integrity of the program to really.
So
wait
just so that we
for
know
the-
where we are, I am not aware of if or when Claudia will be joining us. Linda, do you have any information?
I do not.
Okay, so that's a question mark. I don't think we can just wait for someone when we don't know if they're coming today, because for example, I would not want to put this to the end of the day. Judge Yu, I believe, is joining us around 11 and then has to step away at noon or 12:30. And again, how sure are we that Stephen Hamilton is going to be here later this morning?
He indicated that he'll be here.
I'm sorry, Linda, but what does that mean? What did he?
Let me
Yeah.
find the email, the specific email from him.
While she's doing that, Justice Petru, as the moving party, I'm comfortable moving forward now. And if it's 1 or 2 votes like it was last time, I would defer to your discretion to.
Well,
take
there is a
that
lot.
vote.
Yeah, I mean, there's a motion on the table and I am going to move ahead with the vote on whether to reconsider, but I would like to have a sense for, best I can have a sense for when other people will be joining us.
So just, I found the email and Stephen Hamilton said, I have a brief hearing at 10 a.m. and we'll log in as soon as it's finished. So
Okay, so
he
hopefully
didn't give a
he'll-
specific time.
all right, hopefully he'll be able to join us relatively soon. And if any of you, okay, let's just leave it at that. All right. Do we have anyone else? Stephen, you're the only one with the hand up. So Linda, let's take the vote on whether to reconsider.
Okay. Bashan,
Yes.
Reynoldson, Julia, you're muted.
Sorry, yes.
Felmuth,
No.
Fleischman,
Yes.
Judge Harper,
No.
Hartston,
No.
Kirkmeyer,
No.
McRae,
No.
Olvera,
No.
Robinson. Thought I saw Nicole.
Nicole.
Oh,
She's
Nicole, you're
muted.
muted.
Nicole? I don't think she can hear us.
Okay. Judge Rubin,
No.
Shining,
No. I'm sorry, yes.
Sarouche,
No.
Spyro,
Yes.
and I don't, Torres and Breeze, I don't see Claudia still. Judge Wiley.
No.
Okay, so that's 5 yeses and 1, 2, 3, 9 no's.
So, yeah, so, even putting aside, how one thinks the 2 people that are going to join us are going to miss, I don't think that would change it. So I think that that's how we need to go ahead, all right?
I agree. Thank you, Your Honor.
All right, thank you. So let's then move into Linda or Leah. Procedurally, how are we going through the review of the proposal?
Well, I think what we wanted to do was put up the red line version that was posted and shared, I believe, the day before yesterday. And I think just to be efficient, it would make sense to go member by member to see if people have additional edits that they would like to make. Or we could go section by section and ask every member of the working group if they have any additional edits. The goal would be to have the working group approve their report substantively, delegating to staff the authority to make any technical corrections needed prior to submission to the board. Because, for example, we will have to send the report out for copy editing. And I imagine there's some copy editing that needs to be done. So that's the goal, is to have that kind of approval of the report and delegation of the ability to make technical corrections. So we could go section by section, or we can go working group member by working group member.
I'm a little concerned that if we go working group member, there's going to be a lot of jumping around. It's going to be difficult. You know, like I have it up on my screen and I'd like to actually be able to see it while we're having the discussion. Anyone have strong feelings about how we move forward on this?
Just so you know, I can share it on my screen and I have navigation that would make it relatively easy to jump around if, you know, if that's a concern.
Anyone have thoughts here?
I think section by section might work, just so that we're on the same page.
And then those members who want to comment, can we just raise our hands instead of going member to member?
Yeah, you can raise your hands. I mean, obviously the expectation was that people have, and I know it was lengthy because there's a lot of work in there. But the expectation, of course, was that people have actually reviewed this before today. So I have no problem with going by section and having Linda put it up, but we're not going to, you know, put it up, sit for everyone to read. We'll be here for the next week. Ira?
Yeah, I have I think there's an error actually it's in 5.4. The error is such that I think our version of 5.4 doesn't express what the committee even intended. Well,
let's get that back up there. And are you talking about the subdivision E or somewhere else in there?
E, yeah, 5.4E.
Okay, let me bring that up again.
And it's E3.
Okay.
Okay, so I think the problem with E3 is it says any licensed paraprofessionals. It looks like the S is struck.
Okay, let's stop. Hold on. Let's stop moving the screen if we could.
Sorry.
Anyway, I can't tell if that S is stricken.
The S is stricken.
All right, so it says a licensed paraprofessional should not practice in a law firm with a lawyer if, and then 3, any licensed paraprofessional possesses a majority ownership interest, etc. Well, that would mean that if, say, you had 4 licensed paraprofessionals, each of whom has 20% interest, they would control the law firm. I don't think we meant that. I think what it should say is this: any licensed paraprofessional or any combination of 2 or more licensed paraprofessionals possess a majority ownership interest, blah, blah, blah. In other words, no combination of paraprofessionals, no matter how many, can control a law firm.
Greg, can you weigh in on that?
Greg?
I'm sorry, can you repeat that?
Yes. E3 says that a licensed paraprofessional shall not practice in a law firm with a lawyer if, and then down to 3, any licensed paraprofessional, that's singular apparently, but regardless, possesses a majority ownership interest, etc. So that, as I said before, that means that, say you had 3 licensed paraprofessionals, each of whom had 25% ownership interest, they would control the law firm. That's not what we meant, I'm pretty certain.
I think we changed this the last time so that it was any paraprofessionals in aggregate own a majority interest.
And that, yeah.
All right. That's one way to do it. I had some different words, but just so we make it clear that the total paraprofessional ownership interest can't be more than 49.
Well, which was clearly the intent of the committee. So I'm a little perplexed with this.
All right, well.
Okay, that's a massive change. And I don't think that's what we did at all. And that's the whole point.
Okay, so let's
of-
go back. Carolyn, hold on one second, please, because I agree with you that we need to be very clear on what we did before and whether it's a change or not. So I need, Linda, you need to pause, please. And how is it that we can best see what was actually voted on last time and whether it matches up with this?
I can bring up, you know, my record of what was actually voted on the 16th.
But it could very well be that it just is an edit that didn't get caught or didn't get made.
Well, that's why, Leah, we need to understand what the committee actually voted on to see. Because yeah, there's a big difference between whether it's an individual or all the paraprofessionals in the group having a majority interest.
Sure is.
Oh, we received like 6 or 7 public comments. You can also go through that to see what the public thought this meant. And, but I'll do.
I think we need to, we're going to pull up what we did. And then let's first of all understand with whether Linda's notes from before match what is in the report currently. And then we'll see where we go from there.
This is my record of what was actually voted on. So
who moved this?
Let me see.
Does someone on the committee remember that it was their motion?
I'm looking for it. So Amos moved it and Dana seconded it.
Okay, let's just start. I'm going to have a little bit of a discussion here because again, this is important and we need to, well, all of this is important, but certainly there is a big difference between being one. Amos, can I hear from you first as the person who moved, what your understanding was?
Yes, I agree with Ira and Greg that the intent was a majority interest by paraprofessionals, plural. I do not remember the line edit issue, but I know from the regulation subcommittee and from my moving, that was the intent.
Is there anyone here who, Kimberly?
I believe on page 1274 of the latest document we received, it shows the final that happened at that meeting. And that is that any licensed paraprofessionals possess any ownership interest or exercise controlling managerial. That seems to be the document that captured what happened at the last meeting, if I'm reading it correctly.
Okay.
And I think that's what is meant, and that's what's the cleanest.
Your Honor, I presented this section and the version I presented was this: a licensed paraprofessional shall not practice in a law firm with a lawyer if, and then go to 3, if licensed paraprofessionals possess a majority ownership interest or exercise controlling managerial authority in the firm.
I know, but it's a little confusing to me as to whether that means any individual licensed paraprofessional or whether you're talking about, you know, if there were multiple paraprofessionals as part of the firm that collectively had a majority interest.
I think we received comments about that before, and we had this, if I'm recalling correctly, we had discussed that possibility that more than one each paraprofessional could own a tiny piece, and together they would be controlling. But the thing is that, I don't know, I'm just reading saying or exercise controlling managerial authority in the firm will cover that, doesn't it?
I'm well, I'll withhold my comment because I'm not a voting member, but Carolyn.
Okay, so I think, you know, this is a big change and it needs to be considered. We need to go back and very carefully look at this. Part of, I think, what the trouble we're having is we haven't been writing down the intent of people. These recordings are the recordings, and there will be no, I mean, people might transcribe this someday to look at the legislative intent of what we did. That happens when people challenge laws in the courts. So this is kind of in the going into the vacuum when we ask the moving, the movants, what they meant. When you have a bill, the assembly person writes down and then you have the transcript of what everybody debated. So that's a problem. It's been a problem all along. The second thing is, if you look down, these are rules of professional conduct. They're governed by the Supreme Court, not the legislature in a sense. There's no comments. And I asked Greg a long time ago, where do we put the comments? Because there are lots of comments to this rule. And Greg said that someday the Supreme Court may put those in there. That's actually, I think, COPREC's job. COPREC writes those and then those come about. So that's an empty void. Again, that's going to impact us. And this is, again, we all agree that this is probably the most controversial part of the entire program. So this is not a light thing.
I want to just jump in. I'm sorry. Kim is right. Page 1274 of draft 2, which is posted, does contain the correction. So I think crisis averted. I think Linda was not showing the right document. So
if we changed it midstream, if we changed it from the first draft to the second draft, who did that?
No, I don't think she changed it. I just pulled up draft 2 and it's there. I didn't pull up draft 1. I can do that also.
Okay, but all those criticisms aside, if I can finish here real quick, in a way, Ira's point proves the problem. In a way, even if this is confusing or one way or the other, you still have a way for licensed paraprofessionals to control this. All they have to do is get one lawyer on their side. And so this is inconsistent with, somebody said, with the provision that says thou shalt not share a fee. This is a massive loophole, massive, the entire thing. So we can change this, but let's not kid ourselves. It still means that paraprofessionals are going to control law firms. It's in there. It shouldn't be in there. And so Ira's point may be well taken, but it does not change the fact that this can be construed as letting a paraprofessional control a law firm, full stop.
I'm sorry, just confirming.
No, go ahead, Leah.
The correct version is in both drafts posted. So the issue here is simply that to just put up an older version or something, because both drafts contain the correct version and neither of them, Carolyn, allow for paraprofessionals to have a majority ownership of a firm. So I think the issue simply was having the wrong version posted. What was by the working group is posted for our meeting just now. What's posted on the website reflects the record accurately, and I think there may not be an issue here.
Okay, so how can we, before we take more comment, how can we get in front of us the correct version and ensure that that is what, I mean, it is because it's what's in the draft, but we need to be looking at the right thing when having this discussion.
So Linda, are you able to put up?
Yeah, I'm looking, I want to make sure I have the right thing because there's multiple versions.
Well, you should go to the website, the state bar website, pull up.
Okay, let me just, I will do that right now.
And meanwhile, Fariba.
Thank you. I just want to address Carolyn's comments about the intent of the subcommittee members, and I'm asking Amos and Kim to chime in. My recollection is we clearly didn't want paraprofessionals to have a controlling interest. We didn't want them to supervise the attorneys or direct attorneys' decisions in any way. And so again, I'm asking Amos and Kim if they recall the same thing. And we had multiple discussions. You know that we have had so many meetings. Greg is laughing, so I know he remembers. So the other thing, I'm sorry, I think we're just micromanaging the hell out of this. And if a paraprofessional can get the majority owner lawyer on their side, so what? I mean, it's a lawyer, they can make their own decision. They can decide to agree with the paraprofessional. I just don't see a problem with that.
Okay.
I'm sorry it's taking a moment for this to download to my computer.
All right, Ira.
Yeah, I'm looking at page 1274, and I'm afraid that isn't correct either. I might favor it.
So Ira, let's hold on 1 second with your comments until we can actually see it then, because for obvious reasons. Greg.
Yeah, I just have been going through my notes as well. What came out of the regulation subcommittee and was before the group in August was a licensed paraprofessional shall not practice in a law firm with a lawyer if, and then 1, 2, and 3, licensed paraprofessional, there's no any. The regulatory subcommittee did not include the term any in 1, 2, or 3. It said 1, licensed paraprofessionals direct or regulate any lawyer's professional judgment in rendering services. Licensed paraprofessionals have direct supervisory authority over any lawyer. 3, licensed paraprofessionals possess any majority interest or exercise controlling managerial authority in the firm. According to my notes from the full working group, folks zeroed in on 1 and 2 and noticed that we need the word any in those 2 terms because we wanted to make clear that any licensed paraprofessional may not direct or regulate any lawyer's professional judgment, any licensed paraprofessional, and that for some reason any crept into 3, and that's not, it never belonged there. And there's nothing in my notes to reflect that that was a friendly amendment from anyone. So I'm not sure how it got there.
Yeah, and that is what makes that's what makes perfect sense. And certainly comports with my recollection as well. Leah, if Linda's not able to pull it up, do you have it up? Are you able to share?
I'm pulling it up now. Sorry, I've got it. I'm just scrolling to the right place. Let me just.
And that's part of what was, yeah, it was, and I had my confusion. I've been reviewing the draft that is posted online.
So this version does have the incorrect language.
When we say incorrect language, what do you mean? I
think this was a clerical error on my part in transcribing what was discussed at the
So
meeting.
it is what, so Carolyn, it is what Greg just identified, which is that subdivision E3, the way that it had been discussed, there was no any in there and no striking. It was just licensed paraprofessionals. It is a licensed paraprofessional shall not practice in a law firm with a lawyer if licensed paraprofessionals possess a majority ownership interest or exercise controlling managerial activity in the firm. In other words, it can't be that there are 10 paraprofessionals, each of whom have a 5% ownership interest. And I likewise have no clue how any and got into subdivision 3 or how that was turned into, yeah.
Okay, but it says so the one before said any, and this one is blue. This one is blue.
Jack,
okay, I'm completely confused. I think this needs to be walked through. Whatever version was posted is the version that we supposedly voted on. And so I like to just figure out.
No, I agree with you. So Leah, can we get clarity on what was?
Yeah, I think that that it's messy and that the version control didn't work well. So my suggestion is we just pull out 5.4 from one of these versions, put it in a Word document and mock it up to reflect exactly what the intent is of this working group and take a vote. Because
no, we can't. No.
I object to this.
Hold on, everybody.
Over and over again.
Hold on. People have a right to seek reconsideration. People have a right to make motions, and none of us can say what, that will or will not occur. I do think it is important that the folks be on the same page and that folks know what they voted for and that what is in the report accurately reflect what people voted for. I mean, we're certainly not going to move something forward that doesn't reflect what people actually voted for. And I am, looking to, Greg, Brady, Leah, as far as procedurally the best way to do that. And actually Brady has his hand up, so let's hear from him.
So I was just going to suggest, it seems to me, Greg's explanation comports with both grammar, because, the mistake, however it occurred, is not grammatically correct. and logic, what everybody understood this rule to mean, whether you agree with it or not substantively. So, Greg's explanation makes sense. And I think that one way to handle this, the record on that vote might be a little muddled, but what we're doing here is approving the entire report of the recommendations, which is what's going to go forward for public comment. So to have what makes grammatical and consistently what we've heard is that everybody who voted on this, voted for this, understood it to mean what Greg is saying, so that to make that correction to this version that goes into the final report. I don't see the need for an individual vote on this issue necessarily.
Yeah, that's right, Brady. That's a better suggestion because it's part of finalizing their report. So we're correcting the language in Rule 5.4.
Right, but the question is, without taking an individualized vote, how do we ensure that when we're sitting here making a correction to comport with intent, that it was actually people's intent?
I mean, I haven't heard from anybody who voted for this that wasn't their intent.
Okay. So I'm going to ask that, we just kind of take a pause for 2 minutes while we need to get up what we believe to be the correct version of this so that we can have a discussion looking at that.
I can guide Linda in what I have so that it reflects the intent. So if you bring it back up, Linda.
And I just want to say, I'm sorry I interrupted.
Oh, no.
So go to 1 first. Okay. Make it any licensed paraprofessional directs. You do have that correct. Okay. That is correct. That is correct. You get rid of any in 3. Doesn't belong there. And it should be.
And it should be paraprofessionals. The S should not be stricken.
Yeah, it needs to be there. And then possess, not possesses. And exercise.
If I may, it looks like there's a correct version on page 163 of this long document we have.
Justice Patru, if you think we need a motion to make that change, I do think it's just a conforming change to what
So
the original motion was.
my understanding from Brady, Greg, Leah is that we don't need a motion, that this is a review process, but someone correct me if my understanding is wrong.
That's what I understood Brady to suggest, that this would be incorporated in the overall vote that we're going to ask you to take on the report itself.
That's my suggestion. I mean, it's logical. What we had didn't make grammatical sense. And if you look, what clearly happened was that there were the necessary changes made to 1 and 2, and that change was just repeated on 3, which it shouldn't have been, because there we're talking about do any group 1 or more paraprofessionals add up to a majority, and so therefore you need the word paraprofessionals.
And I can again confirm that was the intent of me as the original mover and also of the regulation subcommittee that did discuss this issue, if that's helpful.
And if there's anyone that voted in favor of this provision that thinks this does not reflect what they.
Well, that was going to be, yeah. So once I finish getting comment from folks, that was going to be my question to the group as a whole, which is why I wanted to be sure that we have in front of us the corrected version. Carolyn.
Again, this all may be Pyrrhic, but we moved somehow to get this back in our discussion. We were told we couldn't discuss it at the last meeting, that it had to be made public. And now we're going to move to change it. I just don't understand the procedure at all. Again, I think this is a distinction without a difference. I don't think this change does what you think it does. But I just, we spend a lot of time doing 1 and 2 and 3. This is not a grammatical change. I don't know, maybe it is. Do you really want to inject this kind of confusion into such an important issue? Can we do this? Really?
Well, and that's why I'm going to ask to see whether there actually is any confusion. My understanding is we did not take a new vote last time because we could not vote in its entirety on something new, or whether to reconsider it. without having it properly noticed, which we did for the meeting today, and we took the vote on the motion for reconsideration this morning. That is different from our function today of going through the report in its entirety and making sure that it actually conforms with a vote that has already been taken. So it's my understanding that the version as it is currently listed, which indicates that a licensed paraprofessional shall not practice in a law firm with a lawyer if licensed paraprofessionals, one or more, possess a majority ownership interest or exercise controlling managerial authority. It's my understanding from the person who moved and from other people that that was the intent behind it, and that was what was originally there. And I'm sorry that there was some issue. And I will say, you know, yes, there was a mistake made here, and that's why we're here to look at it. But, you know, I kind of challenge anyone to put together the amount of material that Linda has had to put together without making any error whatsoever. So I don't want there to be any feeling that I, you know, or anyone else is like, oh, you know, in any way upset with that having happened, because, you know, people are human beings and it's impossible to put this much information together. But that's why I appreciate the close look that everyone has taken to it. Before I come back to you, Carolyn or Ira, with the version that is currently up, is there anyone who voted on this that did not understand this to be the version? You know, I didn't phrase that correctly, but you understand what I'm saying. Did anyone vote for this that did not think they were voting on what is currently in front of them on the screen, which is that the prohibition on a paraprofessional practicing in a law firm includes a prohibition on practicing in a firm where one or more paraprofessionals have a majority ownership interest or exercise controlling managerial authority. If that was not your understanding when you voted, pipe up. Stephen, you just raised your hand and you're muted.
Greg, after paraprofessionals, would the following clause help, comma, individually or collectively, comma, or do you think that's not necessary?
I don't think it's necessary.
Thank you.
And just to be clear, the way 3 is reading right now is exactly what came out of the regulation subcommittee. That's exactly what they put before the full working group. The changes, the friendly amendments that happened after the motion were to 1 and 2, not 3.
May I go, Your Honor?
Sure. And then Ira.
Okay, so the version that we have in the proposed report, in the draft report on page 30 of the proposed rules, which says any, that's a mistake. And then, okay, so that's question 1, because now it has constructive interpretation. If I look at this and I go any, and then no any, I'm going to have to try and define if I'm, you know, a justice sitting on the bench or judge. Any, why isn't there an any? So that's I think confusing in its construction someday down the line. And I'm forgetting the canon, and maybe Steve or Ira can remember for me. That's one question. But I think what we're talking about is, again, it's a distinct, it doesn't need to be in there, because we're saying one can't own, they can own 49.99999%. And that's what anyone, 1 or 2 or 5.
Right.
So it's still the way that people in the public comment were understanding it. A licensed paraprofessional, whether there's 1 or 10 or 100 or 1,000, can own 49.99999%. So that's
Right.
all, that's all the same as we were talking about, right?
That is correct. And the clarification was made so that there's no confusion that you have to add up their interests. So for example, you know, if there were multiple paraprofessionals, when you add it all together, it can't exceed that threshold.
Okay, I think that's okay.
I believe I said Ira next.
Yeah, I just want to point out that there is some history of us adopting exactly what is on our screen now. I shouldn't say adopting. Anyway, the exact same thing is on page, I was wrong before, it's page 857 of the great big PDF that we received before this meeting.
And I thought there was another hand, but maybe it was taken down. It's hard for me to see everyone on the same.
That was me, Honor.
Oh,
yeah, changed my mind.
okay, Fariba.
No, I was just gonna say, you asked if anyone who voted for this agrees with the version that's up, that was what they voted for, and you went to Miss Carolyn who voted against it, I believe. So I just was wondering if there was anyone who voted for it.
So I'll put the question to the table again, and I did not limit it to voting for or voting against. I simply want to be sure that, you know, people who voted on this had the understanding that this, you know, this being what is in front of us and what Carolyn and I just discussed regarding that it's individually or collectively no more than 49.99, as many spaces as you want to go after the decimal point. So I did not see any hands in response to my question earlier on that. I am taking the resounding silence as indicating that this is what people thought they were voting on, and that therefore this does now conform with the understanding. And I want to thank, and I've now forgotten whether, I think it was Ira who brought this back to our attention, and I want to thank him for that, because it's, you know, again, close to impossible for any human being to put all of this together without making a mistake. And it's only by virtue of this kind of a careful review. Now, obviously, this is not going to be the final review that any of this gets. We'll be presenting the, you know, we've already had the discussion about all the steps that happen after this. And I have no idea whether this is going to even be a part of what the State Bar Board wishes to move forward with. So we'll see. But it is important for us to go through the process that we're going through today. With that, is there another section where one or more members of the working group believe that the report does not accurately reflect the intent of the group? And if not, I am going to ask us, you know, again, if there's a particular thing that you're holding, thinking, I really want to make sure to tell everyone about this. And I see Amos and has his hand up. Amos?
Yes, thank you. I do have a recommended change, actually two, both on page 60 of the report.
Okay, so let's get to that report page before you speak, okay?
Amos, did you want me to bring up what you sent me this morning with your suggested changed language?
That would be great, but it might be good to first bring up the report.
Okay, I've got so can you see the report?
Yes, it would be page 60.
Okay, hold on a second.
Internal page 60.
Got it. Hold on a second.
So while you're pulling it up, I'll just describe. So this is the section on statutory and rule amendments that are necessary or important. I think there's an important one that is missing, and that is the proposed rule changes related to UPL, so unlicensed practice of law. I think it should be added to this chart of statutory amendments that the working group has indicated are necessary, are important in standing up the program. And we did have a specific resolution on that. So if you don't mind, Linda, scrolling to the top of the section so people can see what it's about. This is the proposed statutory and rule amendments. And there's a chart showing what those are. And my suggestion is just to add unauthorized practice of law. Find to the end. There is an unlicensed practice of law section in the report, which I think could be cross-referenced as well, so there's no confusion. But I think it's important enough. And to be clear, on August 31st, the working group approved a specific resolution recommending that, and I'm quoting, additional laws, enforcement, and resources addressing unauthorized practice of law and fraud by non-licensees be considered as an essential part of a proposed paraprofessional program in light of the goal to protect the public in connection with the working group's recommendation. So I think it definitely belongs in the proposed statutory and rule amendments. I did send specific language, Linda, if you, actually, do you mind scrolling down so people can see the chart real quick? So it's just the topic, codes and rules and recommendations. And I did put together just a brief suggestion of specific language.
Do you want me to share the recommendations that you sent to me this morning?
Yes, please, for this change.
Okay.
Table 41.
Right. Okay.
Super quick. Linda, I see that this is a bookmarked PDF.
Yes.
And I don't think we got one with the bookmarks that you have, which would be really helpful.
The PDF is bookmarked. If you download it from the website,
Yes.
it's bookmarked.
Yeah, and
You
Carolyn,
can't get to the bookmarks online, but you can get to them. Everything is bookmarked, and in the Word version, you can open up. If you go to the top, there's this view options, and if you click on navigation, it will bring up the kind of navigation that you saw on my screen when I'm looking at the Word version.
Did you email the Word version?
Yes.
Okay,
I emailed the Word version of the first draft. The second draft, the Word version was not sent. It was posted.
Could you send that?
I'll do that, Linda, because you can also convert the PDF to Word, Carolyn, but I'll do that for you now.
Of course, I studied it really, really, really hard. That's hard, but maybe not as hard as
Linda,
Amy's.
Can you see
Yeah,
this? This now?
Yes. Linda, just briefly, just so that the minutes are accurate, at about 10:45, Judge Yu joined us.
Okay.
Okay.
Thank you. And
All
I saw
right.
that Stephen Hamilton also joined a while ago.
Yeah. Okay, great. Amos, would you like to talk to us a little bit about this before I take comment?
Well, I think it's clear. The recommendations are just summarized from the resolution that was adopted. There were a few more recommendations. I don't know if we need to include them all here. I just added a final bullet point cross-referencing the UPL section, but I think the main point is the proposed statutes section of the report should include our specific resolution about UPL.
Okay, Brady? And you're muted.
This is fine. I was just going to suggest if we do go back to page 60 to the prefatory language, changing it a bit because to make clear that that this sort of was developed by not part of the staff recommendations, but developed by the commission.
Okay, so I think let's hold on that until we finish discussing this and whether it's going to be added. So Linda, please go back to where you just were a second ago. And then after we know what we're doing, we can talk about whether the prefatory language should be changed. Okay. Kimberly?
Amos, I just had a question for you. Do you want this in addition to what's in the chart or table 48, where it talks about statutory amendments? You want it listed in both? I just want to make sure.
So is that the part of the section about UPL? Because there is a specific UPL. So I think it should be in addition because there's a separate discussion. But I think if you want to cross-reference, I think that's totally fine.
And Brady, did you intend to still have your hand up right now? Carolyn? And I think you're on mute.
Yeah. The fourth bullet point or the third bullet point, extend the statute of limitations, did we talk about that? That's from the state bar perspective, not the civil litigation perspective.
So that was one of the recommendations that was adopted on August 31st.
That was for the state bar prosecution.
Well, I think it actually came up because of criminal prosecution by prosecutors. That was one of their asks.
Just to be clear, so the state bar's authority to prosecute individuals for UPL is very limited. So if it's a lawyer who has been disbarred or suspended, they follow the normal statute of limitations of 5 years from the date of misconduct. But if it's an individual who's never been licensed by the state bar or is disbarred, because at that point they are no longer considered a lawyer within the jurisdiction of the state bar, then the only thing the state bar can do is refer it to either a local prosecuting agency or the AG's office.
Carolyn?
I'm not sure it answers my question, but I'm going to leave it alone.
Okay, so Amos's proposal, again, not to do something new, but to comport with what the working group has done to date, is to add this into table 41. I believe I heard from Brady that he did not object to that. Is that correct?
Correct.
Okay. And is there anyone who has any objection to our doing that? I mean, I do think it comports with what the working group did. So Brady, Amos, thank you for that. All right, I don't see anyone, so we will add this in to, again, comport with what we have done previously. And then whenever Linda is ready to go back to the prefatory language, Brady, we can hear from you in regards to how you think that should be amended.
Can I just ask for some clarification?
Yes.
About this? So is it this code and rules column is intended to be blank on this, for this section on the table?
Yes.
As it is, and that those will be
Yes.
later identified?
Correct.
Okay, so should I indicate that in here when I'm doing the final version that these will be identified by staff, or should I just leave it blank as it is?
I'm fine with it blank for now.
Okay, thank you. Okay.
So I think that the change, right, is because this refers to staff from OGC reviewing statutes and rules. And so we need to add language that said, in addition, a joint committee, a joint meeting of the regulation and discipline subcommittee.
I'm sorry, I would just say where on the second to last line, where before edits August 31st, 2021 meeting, I would put the regulation subcommittee suggested additional recommendations as well, or made additional recommendations as well.
I think it was jointly the regulation.
It was
subcommittee
joint.
and
I would
discipline.
keep, and this might be, Justice Petru, your call, but this might be the kind of technical edit that we would have the discretion to make, to just clarify who actually put forward these recommendations.
I think that's fine, but while we're having these discussions, I certainly don't want Brady or anyone else to think that they can't pipe in to point that out to us.
I'm fine with both Brady's suggested language on the screen and Leah's suggestion that this is a technical edit that can be handled later.
Okay. Do other folks, I think Judge you had a couple of, not in regards to particular rules, but with some of the preparatory language, a couple of suggestions you wanted to make?
One of them was in the appendix, so I can wait on that. But another was when we were talking about the membership and adding the judges, I wondered if it would be valuable to indicate that, Judges Rubin, Wiley, and Harper represent various different geographical areas of the state, and their experience is so useful because it reflects that. And then also there's a wide variety of subject matter experts, including Judge Rubin and Judge Wiley, who have specialized in family, and Judge Harper, who does everything.
Yeah, so I would suggest on that point, and I remember, certainly that was my thought process, and I clearly remember conveying it to the group as a whole when additional members were added, that the intent was exactly as you indicated, which was to increase judicial representation from a variety of sizes of courts and with a variety of subject matter expertise. So I think I should just say from a large, medium, and small court, comma, with a variety of subject matter expertise Right. Judge, are you okay with that?
Yes.
Yeah, and this really is, I mean, if anyone wants to be heard, that's fine, but that was certainly my intent, and that's certainly what I conveyed to the group as a whole when I announced that the additional members were being added. So this is just kind of background information. Stephen Fleischman?
Yeah, I'd like to talk about the table of contents, actually.
Okay, wait, hold on. I just want to know if there are any comments about this. I mean, I can't imagine this is controversial, but any comments about this, please raise your actual hand rather than your virtual. Amos.
So I like this change. I'll just note, it might be important for the judges as well as us government lawyers to make it also clear in the background section that we are participating in our individual capacities.
Yeah, absolutely.
I second that.
Yeah.
Good point.
You got a strong second on that one, I think, from all the judicial officers for sure.
Yeah.
So where would it make sense to insert that?
Maybe just footnote to the original table that had the members, because it said judges were, oh, is that what you're going to say, Leah? I'm sorry if I jumped in without being recognized.
No, it's fine.
Because we are appointed and it says judicial officers, which was not really a body to appoint us. So, because I think I was appointed by the court or by the judicial council, and maybe there would be a good little place for a footnote that we were.
Well, and it's also different, right? Because that's how you were appointed. And then when I came on as chair, I was, the State Bar Board authorized me to add a certain number of additional members at my discretion. So, I mean, I guess that's the State Bar, but.
Yeah.
If possible, I would like that comment to not just be for judges, because I think.
Oh, no, I think we have to put that for everyone. I was just commenting that these seconds, I think, were particularly, strong from the judicial officers. And I do think it doesn't make sense. I mean, nominating authority is not judicial officers.
Well, it's the stakeholder group.
Stakeholder group, okay.
Because the
I know, but it's not, yeah, but it's really, I don't know. I mean, I don't even know that we're a stakeholder group, but we're not. I mean, we're not, we don't have an interest in this other than, things people, anyway, I don't think we're appropriately defined as a stakeholder group. So.
To me, the stakeholders, as a judicial officer, we really don't have a, up or down on this. And then also it doesn't match the other authorities like the California Lawyers Association and CDC. So it just doesn't seem parallel. But it may complicate things to have to identify who appointed, I think for the other judicial officers, it probably is the State Bar, but for me, it's probably, I wasn't ever clear if it was the Judicial Council or the.
Right. And I just, and Lee, I don't want to complicate things, but I think it's a little confusing to put nominating authority / stakeholder group. And then, someone reads this and it's like, well, wait, what is it? Like, so for me, it says Board of Trustees. What does that mean? Does that mean that that's my nominating authority or I'm somehow representing that stakeholder group? It's just not, we can have further discussion offline because I do think this is something that we don't necessarily have to finalize here with the group. But this is confusing. And I don't want it to appear that the judicial officers are a stakeholder group because they're really not. And also, as Judge Yu said, I think there needs to be some clarity. Like for her, I believe it just says, what does it say for Judge Yu, judicial officers? Yeah, as opposed to like, why is it that we're not listing for her who put her on the working group?
Okay. Well, I think it'll take me a little bit of time to come up with an alternate recommendation. So maybe we can move on to another topic and maybe
I think that's fine. We'll take comment on this so that you can consider that when you're doing that. And clearly we have to, in the prefatory comments or somewhere very clearly indicate that everyone on the working group, not just judicial officers, but that everyone is there in their individual capacity. Because again, while they may be here, as a member, because of a nominating authority, there's going to be a great diversity of opinion within these various groups. So I actually would encourage maybe I would maybe encourage you to think about listing this group based more on nominating authority rather than on stakeholder group. Stephen Fleischman.
Yeah, I was going to talk about the table of contents if we're ready.
Okay, sorry. Sharon, did you have anything on this?
Yeah, no, I would agree with you, Justice Petru, because I think for me it's complicated. It says legal services organizations, and I know that legal services organizations have differing opinions, and I just want to make it sound like I represent all legal services organizations.
Right. And so I think we maybe can take a look at this as far as who are the nominating authorities for the various members and see if it makes more sense to focus on that. But I do think that, as Sharon just said, there's a diversity of views. And so while I think it's important for people to understand how various individual members got on the working group, we have to be careful about saying whose interests they represent. Okay, any other, and Stephen, I know you're talking about the table of contents. Anyone else wish to talk about this? And if not, we will work on it after the meeting. Okay, so then, Stephen, table of contents.
Yes, I'm asking that the dissenting opinions get moved from an appendix to the end of the report at the end of what's currently page 81, and that they be identified by name and page number. So,
okay.
So, large heading dissenting recommendations from working group members. Then below, subheading below that, Stephen Fleischman, page number, Carolyn Shining, page number.
Sure.
Like
anyone
that.
have does anyone have an objection to that or thoughts on that?
This is David, or Judge Rubin. I think it's a good idea.
Yeah, I do too. Okay, so let's give Linda the opportunity to put in the red line so that she can go back to that later to accomplish that.
So if there are multiple people who join in a dissenting opinion, they should all be listed. Is that correct?
I would just list the author.
Okay.
Just for simplicity's sake.
Okay.
And Stephen, did you have something else?
Not on the table of contents. I'm a little unclear how we're proceeding, but I'm happy to go in whatever order Your Honor wants.
Actually, I had asked, and so it seems like what we're doing actually is trying to get individual, what I would like to do is get the individual feedback, and then we'll see, and I'll decide whether we need to go through the sections. But I actually had asked Judge Yu for her input, and I think she had more than the one thing that she told us. So I'm going to go back to her.
Okay, thank you. I had some typo things, but then another substantive question I had was about the appendix, and I think it was Appendix A, page 13. I'm going on my memory. And should I wait?
Erica, let's hold for 1 second until we get to that.
While we're doing that, can I just make an overall general comment?
Sure.
When I was reading it, I was just so impressed with the hard work that was put into it. It was just an extraordinary document, over 1,000 pages. And it was such a nice reflection of all the work, and I kind of felt like Linda or Leah or Justice Petru, who put it together, took all this straw and spun it into gold. Whether you agree with it or not, it was just so much work, and it looks so great. So thank you so much for all of those who put that report together.
Yeah, I mean, Linda has done a yeoman's job, and of course, Leah has done a massive amount of work. And Stephen, I see you clapping, and I agree with that. It is an enormous amount of work that the committee has done, and an enormous amount of consideration about very important issues. So, Erica, are we where you want us to be?
Appendix A, page 13, please. I have to put my glasses to see. I'll wait till we get there, but my comment is sort of more general, but about that. Okay, so when we talk about additional recommendations, I was wondering if we should somehow alert people to what we learned, which I didn't know until I joined this working group, that there are situations where lay people are representing people. And it seems like there's really no no best practice standards or reviewing body. And I don't think that we're the ones to do it, but I'm wondering if somebody needs to know that so that at least there's some oversight. Because look, Steve and I initially met with Judge Dora Padilla in the workers' comp situation, and then we started looking, and there's definitely people representing people when they're not lawyers.
In the admin agency proceeding in particular. So it would be an additional recommendation.
If we think that that is worthy of alerting people to it, or, you know, but it should be looked at. I personally do, but I'm just one voice.
Anyone wish to be heard on whether to add that? Or let me ask it in a flip way. Anyone object to that being added? And I'm not seeing any hands. And so Erica, I think that we go ahead and add it.
I was gonna say I agreed with adding it.
I may object to it, but again, I'm probably a sole voice because I just think we're late in the process, but you know,
well, yeah, I mean, my understanding is that, you know, these are issues or circumstances that we want to flag for the state bar for them to look at and consider and be aware of.
Carolyn, I'm so sorry. I didn't hear the last part of your words. What was the basis for the objection?
It's a whole can of worms that I think it's just a whole new can of worms. It's already regulated in multiple places. So we didn't.
It didn't.
Steve has some thoughts on it. So I'd like to hear what Steve thinks.
Okay, I'm sorry, I wasn't quite finished with that sentence. It didn't seem regulated. It seemed ad hoc from just sort of when we were learning about it. And I wasn't sure if Steve wanted to say anything. Nope.
My hand was not raised on that point, Erica.
Okay, thanks, Steve.
Letting somebody study it, I guess, is fine.
Okay, and I will ask, maybe you can flag this, Linda, that, you know, that's something that we go back and look at just in regards to the exact verbiage.
And maybe it was regulated, but didn't appear to be. Maybe it's not necessary, and I hate to add more work. But that was something that surprised me, and I thought there should be some standard.
The State Bar Board should certainly be aware of.
Yes.
Okay, and then Judge Yu, did you have anything else?
No, thank
All
you.
right. And so I had left hanging Stephen, who had something else he wanted us to look at. Is that right, Stephen Fleischman? Oh,
I have other things in other areas I'd like to address. You just want me to go through?
Yeah.
All right.
Again with the identify the page, let's wait for Linda to be able to pull it up and then go ahead.
It's my page 21 of the red line.
It would be helpful if you tell me what section it is. That's an easier way to
Background and purpose of the working group.
Got it. Thank you.
Next page. I was under the, right there. Nope, up. Right there. I was under the impression we were supposed to be writing this in neutral language. I'm not sure the Justice Gap report is groundbreaking. When I asked the authors why they didn't ask questions like, did you try to find an attorney and were unable? The answer was because we wanted to do it in the same format that other surveys have been done. So I'm not sure that's accurate.
So you
I would
want to
just like
strike the word groundbreaking?
Yes.
That's fine.
Then on the next page, under the heading Justice Gap Study, I made 2 recommendations to Linda that she didn't make. The first one would be between the existing second and third bullet points, 2/3 of the responding parties did not seek any legal help.
Isn't that the same as saying that fewer than 1 in 3 Californians sought legal help?
Well, yes, if you're smart enough to make that connection. I'd rather state it affirmatively. I mean, the main point is the justice gap studies calls that a knowledge gap, not a justice gap.
Okay, I mean, open to hearing from other folks about it. I think that fewer than 1 in 3 sought help is clear. And then it says citing the following reasons, unsure if it's a legal issue, decided to deal with it, worried, didn't know where to look. I mean, it goes through why people didn't, beginning with not even knowing if it's a legal issue or not. I don't have any strong feelings about this. If anyone else wishes to be heard, obviously glad to hear from you. Carolyn. Carolyn, oh, there you are.
Hand up by mistake.
Oh, it's okay.
My next comment in that section is the existing 4th bullet point. Instead of the justice gap exists at all income levels, I'd prefer these findings exist at all income levels. Because again, there's a purported justice gap and there's a purported knowledge gap. So I'd rather just be neutral and say these findings exist at all income levels.
I think that's fine. Where shall we go to next?
I think she needs to make exists exist.
Yeah.
Then 2 pages, my next comment is 2 pages later, table 14. Right there, you're missing a closed parentheses after controversy for Arizona.
Yeah.
And just to be clear, this is going to be copy edited before it's presented.
I understand. Then my next comment is immediately above table 27 on page 43. It's part of the in-court representation. So above that, Linda. Okay, my comments relate to the first paragraph. This was something we voted on very early in the program before most of the judges were involved. I want to make sure Justice Petro and Judge Rubin are okay with it because of their appellate experience.
Where are we? I'm sorry. Where exactly are we looking?
First paragraph. The working group also agreed.
Right. And I do remember some discussion about this.
Okay, I'm sorry.
Oh, no. I mean, it may be that it was decided before I joined, but then there was some conversation about it afterwards.
All right, so my questions are twofold. Number one, I just want to make sure you're comfortable with the language. And number two, do we need to say or add anything about including the filing of notices of appeal in here, in the prohibition? My concern with filing notices of appeal is once a notice of appeal is filed, that triggers a lot of things.
Sure.
Administrative and otherwise.
I mean, I open up the floor here. As I indicated, I do recall there being a reference to this since I joined the working group, but not a whole lot of discussion about it. So again, our purpose here is to make sure that this accurately reflects what the working group has previously decided. Does anyone else wish to be heard on this?
This is Judge Rubin. I agree with Mr. Fleischman. And I like what he said about the notices of appeal because, as he points out, it divests the lower court of jurisdiction, which can really foul things up. I think
Julia? Oh, sorry, David, go ahead.
I think what I might do is Linda added in red or filing notices of appeal. I might either push that after the word appearances.
Yeah. Shall be limited to trial court appearances and shall not include appearances or the filing of notices of appeal.
Right, in any appellate court, including the appellate division of any superior court.
Or filing, yeah, let me read that again. Shall be limited to trial court appearances and shall not include appearances or the filing of.
I like. Okay.
Do you want to just leave it the way it was, David?
Yeah, I don't know.
Okay.
I like
That's
articles and prepositions. I'm trying, Wes.
Okay, shall not include appearances or filing notices of appeal. Then take away the comma after the word appeal.
Right. They're probably better writers than I, but my thought isn't modern writing, we're cutting down on commas.
I would hope so.
The appellate people are nodding their heads.
Yeah.
But I still do the Oxford comma, sorry.
Well, this isn't an Oxford comma issue.
No, I know, but I'm just saying.
Right. Yeah, no, Matt, I
one.
can hear you. Yeah, we can set up a whole other. We can set up a subcommittee on the commas issue, and you and I can,
And one
slog it
space
out
and
on
two
that.
spaces after periods.
Well, I mean, I think we all know the way to define yourself as being over the age of 40 is to use 2 spaces between sentences.
Yes. Judge Rubin, getting to a highly granular level. If you agree about filing notices of appeal, do you agree about drafting or filing notices of appeal?
So as a judge, the rules that I can't enforce, I don't love. If there's something, because it just is a litigation generator, but yeah, either way.
Yeah, I don't know that you're asking my opinion. I don't know that I'm comfortable with adding in drafting because I think it is so squishy and I don't know how we're going to patrol that appropriately, but I leave it up to the group. Julia, you had your.
Go ahead.
I don't think it's necessary to say drafting either, just because, I don't think you can control that. And I just think to put it in there requires some additional worry or something. So I think that perhaps that will be the type of subject that will go in the ethics teaching program of what the scope of services is that every paraprofessional is going to have to study before becoming a paraprofessional. So I think that some of these kind of things that people may see what is considered something that they cannot do, I anticipate that will show up in the curriculum as it is created. Otherwise, but I do agree with the filing notices of appeal. I think it's helpful.
Ira?
Yes, about notices of appeal. What occurred to me is appealing a small claims decision. I don't know if that's technically called a notice of appeal. I'm trying to look it up right now, but I think they should be able to do that. Paraprofessional.
Carolyn?
I agree, but this notice of it, but a small claims appeal is actually a trial de novo.
It is, but notice of appeal might apply to.
Yeah, I have to be honest with you, I've never actually, I've seen it 1,000 times. I don't know that I've looked at how they get up to me. So you're right.
Yeah, I'm looking for it now. On Westlaw.
So Ira, you want the paraprofessional to be able to file notice of the small claims appeal.
Yeah, appeal from a small claims court decision. Yes. In other words, it would say, or notice of appeal except notices of appeal from a small claims court decision.
Are we including small claims in the program? You can't have lawyers in small claims court.
No, but I don't remember. It was
Can I jump in, Ira? So are we then having someone pay a paraprofessional to prepare a request for trial de novo when I think it's, I mean, I did that calendar too, and I can't remember what it looks like, but basically it's a form intended for a person who represents themselves to prepare and file. I'm worried that we're gonna do some of the things that the legal service agency speakers have talked about, which is people are gonna end up paying for things that they don't need to pay for because they could do that themselves. It's pretty easy.
Carolyn, do you have commentary on this?
Yeah, super quick because I agree with this. And as I'm searching through the document, I see everything's consistent with this. But I just trying to find the really nice chart of resolutions that Linda prepared or someone prepared to make sure it's in the resolution. As Julie mentioned, it is probably going to be in that the training materials. The resolution chart is so helpful and will be, you know, so make sure it's clear in there. That's what I'm trying to find it and see if it's in there.
Yeah, so we can flag to follow up on that and make sure that it is clear.
I don't know if we need to amend our resolution or do a separate little tiny resolution. There's a lot of bullet points, what's excluded.
Yeah.
And we can move to amend to throw it in there.
I don't think that the summary chart, we need to have a motion. I think that since we are now modifying this to include filing notices of appeal, we can ensure that that summary chart lines up with this. Erica?
Yes?
You have your hand up, young lady.
I'm sorry, I forgot to take it down after I asked Ira the question if that was what he intended.
No worries.
Thanks, sorry.
Okay, so is there more on this? I don't think so. All right, where shall we go next?
Page 63 under fee, I'm sorry, 61 under fee caps.
All right, let's give Linda a minute here.
Can I ask a question real quick before we move on?
Go ahead.
All right, can we scroll back to where we were? Well, no, let's scroll back. We say in the document about filing notices of appeal, but is that actually in our language? Other than in the report?
Do you mean, is it in a resolution somewhere?
Yeah. Or is this going to be it?
I don't think it's in an actual resolution. I don't think that was something voted on. I think it was, as Stephen said, it was more discussed and understood.
Yeah, most of our resolutions were more affirmative.
Okay.
Rather than focusing on what you can't do.
Okay, very well. Thank you.
Julia? I'm sorry. Go ahead, Stephen.
All right, so my comment is under the heading proponents of fee caps advance the following arguments. I sent Linda 2 suggested changes, which she did not make, and I'll just read them. The first one is, because contingency fees will be limited under the program, individuals hiring paraprofessionals under the program will be billed on an hourly basis, paren, unless a flat fee is agreed to, close paren, and most consumers are not familiar with reviewing legal bills and determining what are appropriate and inappropriate charges. And then the next bullet point is, there's a vast amount of data available, including Superior Court local rules, demonstrating market rates for legal services in various areas. Linda's comment was she didn't believe these comments were advanced during the meeting. And my recollection is otherwise. I recall discussing, for example, quarterly hourly billing with Steve Hamilton, and he said, yes, he bills on a quarterly hourly basis because his retainer agreement says that. And I said I was in favor of requiring billing on a 1/10 of an hour basis. We also talked a little bit about block billing problems. We certainly discussed at length the tremendous report staff put together with all the information about market rates. Now, I'm not re-arguing the substantive point, but I think under the heading, arguments in favor of their position. These were arguments, at least I advanced, about why there should be fee caps, and I'd like to have those 2 points added to the report.
Okay, Stephen Hamilton.
I just wanted to clarify. So I actually bill by the minute. I run a timer so that I give actual times.
Okay.
My retainer agreement and the retainer agreements I always see typically do include almost this flat fee charges of if you write a letter, it will be no less than a 12-minute or a 15-minute charge. So I know that there are practitioners that are out there that do that by billing in blocks and or prescribe minimum charges for certain activities. And I think that's the problem that Steve Fleischman is addressing. I just want to make it clear. I run the clock and just do actual time.
Okay, Carolyn and then Ira.
So these are just changes to what we discussed, not the actual rule itself.
Correct. It's not the actual, this is simply in regards to a summary of the arguments for and against the fee caps. Ira?
I have a memory that both of the things that Steve Fleischman mentioned were discussed.
I do as well.
Okay.
So
put those in. Look, we have the language. Is it okay with the group if we say that we are going to insert it rather than watching Linda type it in now?
Yeah, that is fine.
Oh, she did it. Okay.
Linda, you're amazing.
And I'm open to friendly amendments to clarify.
Well, I mean, I think this is simply a summary of arguments. You made this argument. It is not, this is not saying that everyone who was a proponent or opponent agreed with it. This is just a listing of arguments that were made, so it's fine. Stephen, did you have another section you would like us to look at?
At this time, no.
Okay, and does anyone else have another section they would like us to review? Amos?
I have another proposed change to this fee cap section, the introductory paragraph on page 60.
Okay, let's wait a second and get there.
So I believe it's important context to the discussion and framing of the discussion that the working group as a whole and the regulation subcommittee identified the risk of charging excessive fees or unreasonable fees was one of the primary risks that was identified for potential regulation. So again, I think it's a neutral point, but that I think that context.
I'm sorry, I think my brain just flatlined. Can you say that one more time?
Yeah, so both the working group, the full working group and the regulation subcommittee identified the risk of the charging of excessive fees or unreasonable fees as one of the primary risks that should be considered by for potential regulation. Again, I don't mean to re-argue the point. I just think that's very important context because I think just reading this section, that point is lost and it might just be, maybe it's good, maybe it's bad, but I think the working group and the regulation subcommittee identified 3 primary risks that it was trying
and so
to
you
address.
want to basically make it more explicit where it says where with a particular concern that vulnerable clients could be taken advantage of absent fee caps. I mean, to me, that has, that addresses what you're saying, but you're saying that you want it to be more explicit to say something like with a particular concern that vulnerable clients can be taken advantage of absent fee caps, for example, by excessive billing?
No. Linda, do you have the proposed language that I sent to you?
Yes, let me share that. Can you see that now?
Yes. So again, I think this is important for context. I think it was suggested that, well, the bullet points or the arguments for or against are below, but I think the background context of why we were discussing this, why it was an important, why we had a separate meeting, was that it was one of the 3 primary risks that were identified by the regulation subcommittee. And so I just think that context is important and shouldn't be lost.
Carolyn?
With all due respect to Amos, this is argumentative, and if it was discussed, it was in the for and against. So I think this should go in the for and against parts. So
if I could address that. So I was one of the people who presented on this, and the regulation subcommittee is here, but I have no problem with the for and against arguments. But when I reviewed this report, I thought that this point was totally lost. And I think it's an important one for context of the discussion.
Yeah, I think it's too detailed, honestly, because I think you can make the same argument for, what is financial viability of a paraprofessional career, the free market principles, any one of those could be expanded out further. If there's some desire to, again, flag vulnerable clients could be taken advantage of absent fee cap. Personally, my view would be that as a summary introduction, it would be okay if it said something like, with a particular concern, the vulnerable clients could be taken advantage of absent fee caps, for example, by excessive or unreasonable fees. I don't even know if we want that, but I do think that this proposal does go, I don't know if argumentative is the right term, but goes further than what the introduction is meant to do. So if there's some way to flag the excessive fees issue without going into this level of detail, I personally think that would be okay. I'm happy to hear from anyone else on this.
Yeah, and so I'll just respond to that by saying, if you think it's too detailed, I think that it could be trimmed back, probably the particularly clause at the end could be trimmed back, but I think the first part of the sentence is the primary thing that I think is the context that's important.
I just want to say from a staff perspective, we thought this was argumentative also, not argumentative in the, we thought it was advocacy. But we did modify the language in that paragraph to make it a little bit stronger. So, we did try to address the sentiment, Amos. I just wanted to share that.
Yeah, no, I did try to talk to staff before that. I think this was a particularly sensitive issue for staff, so I'm not sure what the concern is, but again, I'm just trying to be factual, and it is factual that fee caps was one of the 3 primary risks identified for potential regulation, and skipping that, I think, makes it an unfair summary of the discussion.
So I'm going to ask that we go back, and I'm happy to work with Leah and Linda on it, and Amos, you can chime in, that we do a little bit more on kind of like to make it clear, rather than saying taken advantage of, like we make some clarification, and that we're talking specifically, that a primary concern was excessive and unreasonable fees, but not this whole thing. This is an advocacy position that is better put in the pros and cons. So Linda, if you could flag that with the things that we're going to go back on.
Thank you.
And Amos, did you have another section you wanted us to look at?
No.
Ira?
There's a page that about a dissenting opinion that is very confusing, I think.
Can you help us find where it is in the document with the header or anything?
Yeah, well, let's see. The page starts out with these words: the following dissenting opinion regarding fee caps was submitted. And on the PDF, it's page 1407.
Let me pull up the Word version of the dissenting opinion. So which dissenting opinion is it? Is it the fee caps, or is it Rule 1.4.3?
Well, it's fee caps.
Okay, hold on. Let me just pull that.
Can you say the page number again?
1407.
I think it's the last page, the last 2 pages of the document.
Oh, yeah, it is. All right, so what's confusing is it looks like the bullet point is the resolution, but actually it's the opposite.
So that is what is being dissented to.
Yeah, what I mean is it looks like the bullet point is the dissenting opinion, but it's not. It's what's being dissented against. Somehow that needs to be clarified, I think.
Leah, do you have any thoughts on this? Oh, Leah may have stepped away.
Yeah, I had to step away. I'm sorry. Can you repeat yourself?
Yeah, on this page, it says the following dissenting opinion regarding fee caps was submitted. And then instead of giving the dissenting opinion, it shows what the dissenting opinion is troubled about. It shows the resolution. So it needs to be clarified. It's really confusing.
Okay. My understanding, Linda, is that you did not edit these dissenting opinions.
That's correct. I just took them exactly as they were presented.
I don't think it would be appropriate for us to edit, Ira. I think if you're part of the dissenting opinion, which you are, then maybe your group wants to get back together and redraft the dissenting opinion, and we will put it in as you provide it to us.
This is exactly the way it was proposed, really?
We didn't edit any dissenting opinions.
Well, let me see. There's 5, 1, 2, 3. There's 6 people who proposed this, whose names are on the bottom of it. On my version, Claudia's name is stricken on the PDF I'm looking at.
Correct. She did not want her name on this.
Yeah. All right. So if I suggest this, rather than having to go back, I understand, Lee, that it might be better to go back, but how about this? What if it simply said a dissenting opinion regarding fee caps was submitted in light of the following resolution, and then it says resolved. And then if all 6 of us right now say, yeah, that's what we meant, then we could do it.
Well, do the other folks on this want to be heard? Amos?
I think it's another good catch by Ira. And I think probably the best solution is if there was some standard way the dissenting opinions were going to be listed, because each of the dissenting opinions is going to be dissenting to some resolution or some portion of the report.
Right.
So I think that should probably just be standardized so there's no confusion.
Linda, does that work for you?
Well, I have a little bit of trouble with staff drafting or editing the dissenting opinions. It seems like they should be written by the author and in whatever format, because I am expecting dissenting opinions to be provided by other people. I've been advised that they're going to be submitted, and I don't think staff should have to edit them
do any editing of it.
a certain way.
Yeah.
Can we just agree to what a standard format should look like then, of how it's going to reference the portion of the report that it's going to be dissenting to, so it just can be standardized?
Right, so that we're not editing what was submitted as a dissenting opinion. But, and that of course presumes that the person submitting the dissenting opinion has identified that. I mean, I think that's where it can get a little bit tricky potentially, is, if there's any lack of clarity about what the dissenting opinion is actually going to. Julia?
Yeah, I'm listed as one of the dissenters here, and I think Ira's correct that if we would just agree to say, and it doesn't have to be standardized unless others in the other dissenting opinions agree. I just think of the following dissenting opinion regarding fee caps and the following resolution was submitted, : but I think that way it introduces that this is the resolution that is being dissented to. And so I believe that if Those are
Okay, well, hold on a second, then it can't say and the following resolution, so it should be the following dissenting opinion regarding, oh, I see, it's a little confusing.
I think Linda had a,
It could say the following resolution regarding fee caps.
well, I think Linda started out pretty well saying a dissenting opinion was submitted
Yeah.
regarding the following resolution by the working group.
Or the
Sounds good to
following
me.
resolution regarding fee caps. Either way, but I think that introduces the resolution and it doesn't come across as confusing.
Okay, a dissenting opinion regarding the following resolution regarding fee caps was submitted. Yeah, that's better.
I think we probably need a conforming change on the next page as well.
Okay, let's go back up and
Yeah.
wasn't not accepting your, okay.
You've got two regardings in there.
Yeah, go back up, Linda, so we can take a look at it. A dissenting opinion regarding the following resolution
On fee caps?
yeah, on fee caps.
Maybe it should be a dissenting opinion regarding the following fee cap resolution was submitted.
That's fine.
I like that. Good, Amos.
Less work is always better.
And I do think we'll need a conforming change on the next page, the same issue with the other dissenting opinion.
So I'm sorry, where are we looking on the next page?
I think Linda's pulling it up.
Yeah, I mean, I think we can just go through and make sure we conform to say a dissenting opinion was submitted.
Yeah.
Right,
Maybe
we can do that offline. We don't need to do that while we're all sitting here.
Right.
Stephen Fleischman?
Yeah, just 2 points. I agree with the comments that staff should not be editing the dissents, but I disagree with Amos that all the dissents have to follow the same format. I have a draft of the dissent that I think other people will be joining. It doesn't follow this format, and I don't want to go back and redo.
So I'm gonna insert my prerogative here to say the place where I'm asking folks to be consistent is I'm asking staff on just that introductory sentence to be consistent as to how we're introducing the dissents. And then as far as the actual formatting of the dissents, I am not imposing any kind of formatting requirement. However, anyone wishes to put together their dissent, they can do.
Thank you, Your Honor.
Amos, did you have something else you wanted us to look at?
Yeah, just real briefly on the dissents that we were just looking at. So there are 2 dissents in the draft report that were circulated at the last 2 pages. My understanding where there were originally 7 or 8 people signed on to each one, and I believe our staff has been contacting them and people are changing their votes. I just want to make it clear.
Let me want to be very clear. I don't want any insinuation about a changing of votes or staff influencing. And and I'm happy to ask staff to show me or you the emails. I've only seen one communication, which was a very neutral, are you a signatory on this? And so I just am going to step in to ask that you not, if you think staff has done something improper, go ahead. But if that's not your intent, don't insinuate that. I'm also going to say that everyone has a right to decide whether or not they wish to be part of a dissenting recommendation or thought or suggestion. And they're also free to change their mind until this has been finalized. But with that, what did you want to say, Amos?
No, I appreciate that. And that's actually what I wanted to say. And I'm glad you said it because I just want to make it clear that people can decide for themselves what dissent opinions to join. And I don't think they should I think people should feel open to make their own decisions, regardless of what the vote is. I understood some people interpreted the bar staff's comment to suggest that if they voted one way, they shouldn't be able to join a dissent. And so I just, especially with 1.4.3, where the dissenting opinion does not challenge the vote on the rule, but says it doesn't go far enough and adds edits. I just want to make it clear. I don't think anyone should be feel like they're not permitted to join any dissent.
Absolutely.
Can I speak to that?
Sure.
The reason that I sent out confirming emails to the people who Amos indicated were signatories is that they were not copied. So I was just sent a list of these are the people who have agreed to sign on to this dissent. And if in the future, if you send, if any dissents are sent to me with other signatories, if you can be sure to copy the other people so that I can see that they are, can object or agree or whatever, because I had no way to independently verify that. And I felt just due diligence required me to do that.
That's completely appropriate and fine, Linda. And as a matter of going back to what the protocol should be, although I'm not imposing any kind of, this is the format that your dissenting opinion takes on. If you are submitting a dissenting opinion and you have other signatories to it, copy them on the communication. We don't want to put staff in a position of having to follow up or wondering, because they do. I mean, if people are not copied, there is going to be a need to follow up.
And if I can interject quickly, it's very good that she did that because I believe my name was originally included on that. And Linda had to share it with me and she knew that I had actually abstained from that vote on purpose and was not joining in that dissent.
Yeah, and I just also want to interject quickly. I totally agree with Justice Patru that I did not mean to insinuate any improper conduct. I just want to make it clear because I think there may have been some confusion that anyone should be able to join any dissenting opinion they want, regardless of what their prior votes may have been.
Thank you, Amos. Carolyn?
Okay, this might be a simple solution to this because the word dissent is something that we're going to do in Appendix G, and that is going to be a different type of thing. I thought the dissent might be called alternative proposal or something perspective, but if for this, these are alternatives or, we never used the word dissent inside our committees and subcommittees. So people proposed alternatives, they propose friendly amendments. So you might want to say an additional motion, a different motion. Inside our groups, we never said dissent. The word first I heard about dissent was when the final, with this final thing came up, and then someone suggested that we would be able to put together alternative dissents. And that came from staff, that word. So I would just say that a differing, an additional, a different motion was proposed, submitted is, I guess, fine. But then the second thing is, and we can talk about that, the second thing is, if there are going to be changes to this after today, how are we going to know how to vote today?
The only changes that are going to be made are going to be non-substantive that we have already flagged. And actually, I don't know how many there are left at this point. We can go through after a lunch break perhaps and list those, but there is going to be no substantive change. And it's my understanding that the working group, first of all, there's going to be line editing that has to happen, right? This document has to be sent out for where's the missing semicolon or closing parentheses or that kind of thing. I certainly don't think that needs to come back to the working group. Anything substantive, we've had an actual discussion on today, but I don't think that, I don't see the issue with moving forward today. If there's any kind of confusion about what has been left in staff's hands, we can look at that over a lunch break. Julia, you're raising your hand?
Yeah, I want to stick with the dissenting opinion because unless you actually made a motion that was seconded and actually made an affirmative proposal, which was then discussed and voted upon, I don't want to change what the intent was. If I have signed on to a dissenting opinion. I'd like Amos to keep it a dissenting opinion. And if Carolyn has one that is listed as a dissenting opinion and she wants to state it as something else other than that, then I think that's fine. But for those of us who did sign on to a dissenting opinion, that language was being used and it was not an alternative that was made as a motion or that was actually voted on by the group. It was discussed. And so I'm okay with calling it as such.
Stephen, oh, sorry, go ahead.
What was it? I guess that's, again, we have to go back to the video. I don't recall any use of the word dissent ever.
Oh, I mean, I do, but Leah?
Not only that, we had a specific discussion, and I think we might have followed it up with an email from Brady about the process for drafting dissenting opinions. And so the process has been followed. Several members have drafted opinions. They've been signed on to by various other members of the working group. So I'm a little confused by the confusion, but happy, I think, if you want to pull yourself out of one of the dissenting opinions that you signed on to and perhaps write a separate alternate document, we'll be happy to include that.
That's not what I meant. This is what it is. And people, I think when it says resolved in there, I would assume that that was a motion that was presented. And whether it was actually, I mean, resolved is somebody sat down and we typed it out and Linda typed it out. So, you know, there's a lot of things in here that aren't, there's votes that aren't mentioned by name and it just says 4-1 or whatever. And so this one is odd. It sticks out. It's in a very controversial area. This is probably the second controversial area. And again, any change to this, I would say is substantive in my view. So this should be, the word dissent, if there's a memo or an email back and forth that was not, you know, given to the group, I'd like to see it.
No. That was something that went out to the entire group. I'm maybe there's something I didn't see, but I'm not aware of some separate email about calling these, you know, referring to these as dissents that, or the procedure that didn't go out to the group.
Yeah, I mean, I'm going to have dissents in the Appendix G, and that's what it's been called. And there definitely were disagreements and alternatives and additional or varying proposals constantly. So dissent seems to me to be what we put in our official dissent. I don't want a confusion as to this should be in Appendix G when it's a resolution we put into the meeting. So right. It's just, it just changed the language. The following alternative opinion was submitted to the, you know, and got voted down.
Mm-hmm.
There's a lot of places where there's votes and no names mentioned. And here we name names. So, but people aren't writing, I don't know, maybe there'll be a written dissent by the people who are identified in the thing below here. So, do you see what I'm saying? If this is going to be a written dissent, then it's a dissent, see Appendix G.
Okay, as opposed to an alternative recommendation?
Maybe people remember that in the meeting they called it a dissent.
I have a strong recollection. We discussed the ability of voting of committee members to write dissents. It's been discussed on more than one occasion. And I also think earlier today, Carolyn, we agreed to move it from Appendix G to the end of the existing report and identify it by name of the authoring committee member.
And again, I have no problem if someone wants to submit something that says this is an alternative recommendation and we do the header as dissenting / alternative. I don't have an issue with that. But again, I'm not going to, and I'm certainly not, you know, expecting staff to modify anything that came in from anyone. So however you want to call yours that you send in, so be it.
And if I could just clarify, I think there just might be some confusion. The dissents that we're looking at are intended to be Exhibit G dissents.
Right.
And now I think they're going to be moved from Exhibit G to the end of the report, but these were submitted as Exhibit G dissents.
Okay.
And can I add?
So when you say this was submitted, the title of it says, okay. Submitted by the sign. Okay, I got it. It's I see the format. Submitted after, for inclusion into the final report, not discussed in any meeting, but.
Right, exactly.
Correct.
Exactly.
I get it.
I thought I saw another, oh, Kimberly.
Thank you, Justice Petru. I had a couple other things if we're ready to move on for the report that I wanted to bring up.
Sure.
It's actually in the beginning, kind of like in the executive summary, and then also in the licensing. So it's in the licensing requirements in the executive summary, and then also on page 44 in the licensing requirements.
Okay, where would you like, hold on, where would you like us to look first so that Linda can look for this?
Page 11, licensing requirements. So at the very beginning. And it's kind of more like an overall general statement. And I'm curious to the other readers of the document. And that is that in all of where we talk about licensing these individuals, it just isn't laid out clearly to me in the beginning that these individuals, while they're going to go through this training and it has to be specific to their practice area, that they're going to actually have a license that's issued and tested specifically for one practice area. And while it's kind of implied to the reader who's on the outside and hasn't been a part of this whole working group, I'm just not sure that that's clear. So I didn't put any document or wording together on it, but I kind of wanted to see if others agree with that. And so that's kind of my comment in both of those two sections.
And I think we added that language in further on, not in the executive summary, but in the more detailed discussion, but we could add that language. I'm just going to go to this.
It's kind of down in there, Linda. I did see it in there, but it's just
okay.
I just don't know that it's clear.
You're thinking, Kim, like an introductory sentence that just lays out the licensing will include educational, experiential, and testing and a moral character application process, at the conclusion of which a paraprofessional will be granted a practice area specific license.
Yes. Yeah, just something that they're going to be very specific to those areas. I don't think that it's clear, and it looks like almost they're just going to get a license when that's not the case. They're going to have to get, a couple different practice area licenses. And then the other section is
hold on, Linda. Linda, are you done putting in your comments so that you have enough to go back to? Okay.
Yes, thank you.
Go ahead, Kimberly.
Right. And then the other one is at the very end on program evaluation section. And it's actually footnote, I believe it's still 41. It's talking about general fund loans.
Is it 44? Is that what we're looking
44
at?
now, sorry, it's been changed, 44. Just that last sentence, and a loan from the Bureau of Automotive Repair to start the Bureau of Naturopathic Medicine. That actually was, it's called a Section 14 loan. It wasn't a general fund loan. So one bureau, they borrowed money from one bureau for another bureau. So I just don't, if there's any readers and they say that's not a general fund loan.
Okay, and I think that's why I specifically said a general fund loan for this first one, a general fund loan for the other one, and a loan from the Bureau of Automotive Repair. Should I specifically say a loan and then say which was not from the general fund?
Maybe it's clear. Yeah, that'd be great. Yeah.
Yeah, let's do that. And also at the very beginning of that footnote, it needs to be examples, plural.
Thank you.
And that was it for me. I just want to say thank you to Linda and Leah and all the individuals who reviewed it. It was a very good document with a lot of information.
All right, thank you, Kimberly. Carolyn?
You're on mute.
Oh, his hand was not dropped. I'm so sorry.
Oh, no, it's okay. And I do appreciate, I know it's hard for people to go on and off mute, but I do appreciate that everyone seems to be doing that because it really does cut down the background. So while it can make things, take a second longer, I appreciate that everyone's been doing that. Okay, do we have other individual suggestions for revisions or edits? Okay, not seeing any, and with an, let me ask this. Are folks ready to move ahead with a general vote at this point? Obviously, someone would need to move it, or is there a preference? There were a few spots in which Linda made the side note for following up later. Would you like to kind of go over what those are before the vote's taken? You can just speak up. You don't need to wait for me to call on you.
Just to make sure everyone has the same review, I think that would be helpful, Your Honor.
Yeah, I do as well. So what I'd like to do, actually, it's 12:20. Carolyn?
Oh, are we going to do a formal resolution on the screen, or will it just be a voice vote or something?
I have a formal resolution prepared.
Okay, could we see that before we do a lunch break, maybe?
Sure.
Yeah.
And then while Linda's doing that, Justice Petrie, were you going to want to see a list of all the necessary edits that we identified?
Yeah, which is why we're going to take a longer lunch break than usual to allow, Linda and you to actually do that, and maybe actually have 10 minutes to eat or drink something.
Okay.
Okay.
So can everyone see these resolutions?
Yeah, I'm going to read through them. We're not going to, obviously it's not for voting right now, or I'm not asking for anyone to move, but just so we know what the intent would be. Resolved that the California Paraprofessional Program Working Group approve submission of its report to the Board of Trustees reflecting the changes adopted at its September 10, 2021 meeting. Further resolved that our group authorizes staff to make technical, non-substantive changes prior to submission of the report to the board for consideration at its September 23, 2021 meeting. Stephen Fleischman.
Yeah, I think for the first paragraph, it should be after meeting, comma, subject to the addition of dissents written by individual working group members. As I understand it, we have till Monday or Tuesday.
Yeah. But I don't think it's subject to. I mean, I think so reflects the change, approved submission of its report to the Board of Trustees, reflecting the changes adopted at September 2021 meeting, and understanding that additional dissents or alternative, what was the language that was used?
Proposals.
Yeah, and that additional dissents or alternative proposals will be accepted and added up to whatever the date is. Does that work for you, Stephen?
Absolutely, much better than what I said.
I didn't even let you finish what you said, so, so we can't make that assessment.
It's Monday, Linda, because we've got to get it to copy editing and remediation.
Okay, so the 13th.
Mm-hmm.
Yes, September 13th. And thank you for catching that, Stephen, because yes, there may be other things coming in, and it needs to be clear that those will be added to the report. Okay, anything else before we break for lunch? I don't think so. It's 12:20. Linda and Leah, does it work for you if we resume at 1, or would you rather 1:15?
I think 1 is fine, but
yeah.
Okay. All right, then I'll see you all at 1 o'clock.
All right, thanks.
All right, thank you.
Thank you.
who would like to make public? Is there anyone in the attendees who would like to make public comment? If so, if you could please raise your hand. Okay, I am not seeing any requests for public comment. I know, Judge, you wanted to be back with us, but she's in a meeting with in regards to her young adult court that needs to go forward. So we're not going to wait for her. Linda, do you have some sort of a summary for us to look at in regards to, you know, the post-meeting changes?
I'm still working on it.
Well, and that's why
I have it mostly done.
No. We're not going to rush this, and it can't be mostly done. We have to have a complete list. So how much more time do you want to? Do you want us to resume in 10 minutes? Do you want what works?
I think
for
10
you?
minutes would help. I think I want to be sure that I've got a thorough list.
Okay. Let's go ahead and then pause for about 10 minutes till 1:15. Okay. Thank you very much, everybody. Wait for everyone to be back. I'm going to wait for some more committee members to be back. As you come back, if you could please turn on your video, I'd appreciate it. Sharon, do we have you? I see Judge Harper just. Yes. Okay, so it looks like we have everyone. So Linda, go ahead.
So I can share the summary of the changes that I've noted that will be made. We can, do you want me to read each one of them?
Sure.
Okay, so the first one is the correction to Rule 5.4E3, anywhere that it appears in the report. And this is the language that will be used.
Well, Linda, I don't think it's anywhere that it appears in the report, because why we kept seeing it in all these different places is because we have the various iterations of the rules that were submitted as proposals at different times.
So it's where, right.
As the final recommendation of the working group.
Okay. And the next one is to add the UPL statutes to the table on page 60. And I'm going to be using the table that I shared that Amos provided, adding that line to it. As well as in the summary of all of the recommendations. I think that's, I have to go back to see if the specific statutory changes are included in that. It might not be. Then there's language in terms of adding the judges to the working group.
Right, we went over that, right.
For that. And then I think the suggested heading for that table 1 is nominating authority / affiliation. Does that work for people? As opposed to stakeholder group? But that will add the language to that specifically says that people are participating in their individual capacity.
Why is it that we can't just do nominating authority?
Yeah, I think, Linda, in the notes I wrote it, we said we would just finalize this with Justice Petru.
Okay.
Yeah.
Okay.
Because again, we do have that footnote or wherever it is indicating that people are here in their individual capacity, not representing anyone. And if we can just leave it to nominating authority, I think it is cleaner and more accurate and appropriate.
Okay, that's fine. So then I've added that rather than having the Appendix G, the separate dissenting opinions, that's now added to the body of the report. So it will show up in the table of contents, and the names of the authors of each dissenting opinion or alternative recommendation will be included in the table of contents. In Appendix A, we're going to add the recommendation that the state bar consider recommending standards of conduct for non-licensed representation in regulatory agency proceedings. And then in the section that discusses the exclusion of appellate work, we've added the language, and I think we already showed that the filing notices of appeal is also excluded. In the fee caps discussion, we've added the language provided by Stephen Fleischman, the reasons in favor of fee caps. That language will be added, and I think I showed that on the screen when we were looking at that. We're going to incorporate some additional language in the introductory paragraph to the fee cap section, saying that a primary concern was excessive and unreasonable fees. We're going to add in the discussion about licensing requirements, and this will be both in the executive summary as well as in the body of a report, to clarify that licenses are practice area specific. And then the last thing that I noted was that we've deleted the word groundbreaking in the reference to the justice gap study and changed the justice gaps exists at all levels to these findings exist at all levels. So is there anything that I missed? I see Julia, you have your hand raised.
Yeah, Julia.
I just wanted to know if we'll be able to get a copy of this.
You mean before it's submitted to the board?
A copy of your list.
This document.
Oh, this document. Yes, I can provide this document.
That will be helpful for our review. Thank you.
Okay. All right.
And Ira?
Yeah, maybe I'm not seeing it. The revision of the dissenting proposals to clarify that which is the dissent and which is the thing they're dissenting against.
You mean that introductory sentence?
Yes.
Right, I don't see that on here either.
Okay.
And did we clarify that it was just for the two specific dissenting opinions? Because I think Stephen Fleischman indicated the structure of his is going to be different. So I think we made the change in the one, and then Amos indicated that the next one would also need to be changed.
Yeah.
Versus all dissenting opinions. And I think, Linda, when in the draft I sent to you, I might have referenced the dissenting opinions on fee caps. I can't, because I did have something in my version on this.
Okay, I'll have to look at that.
But Justice Petra, I think that's your call. I originally.
Yeah, I mean, I'd have to go through and look at each one to see where, what makes sense. I mean, I like, consistency, and just in the sense of like this, dissenting opinion or alternative recommendation was submitted in response to proposal X, So, I mean, I don't see any reason why we wouldn't use that. If it's the staff, I'm not talking about language that was submitted, but if it's the staff language of how staff is introducing the dissenting or alternative recommendation, I would think we would want to use consistent language.
Okay, so if it's submitted without the introductory language, then I can add that same consistent language. And otherwise, if it's submitted just as a letter,
right,
in some other final format, then I won't be making any edits to that.
Yeah, and presumably the letter will say I'm writing in regards to.
Okay.
Ira?
No, yeah, I agree. I'm sorry. I should have lowered it.
Oh, it's okay. Anything else that anyone feels was not captured? Okay, so with that, can we go back to the proposed resolution and see if we have someone to move?
Okay, hold on one moment. I just want to make sure I save this document.
No, take your time, Linda.
Yeah. Okay, so I've saved that. I will send this out. And find the right, I just need to find the resolution.
That's okay.
I have too many documents open on my desk.
And is that a picture of where you're going to escape to when this is all done?
Let's see, let me just see. Okay, so can you see that now?
Yes. And Ira, your hand is up.
Yeah, I'd like to add something or other that expresses this thought, that a yes vote by any member of the working group doesn't mean that the member agrees with every provision in the what are we calling it, proposal?
No, exactly. I mean,
Vision.
Obviously, this is not saying that we agree that, you know, you're now voting yes on something you previously voted no on. This is a report reflecting what has occurred and incorporating dissenting or alternative proposals. So I don't know, I'm trying to think about how, and I think that's self-evident, but I'm trying to think about how one would say that. And Stephen Hamilton just raised his hand.
Yeah, I actually agree with Ira on that one. I think we could include a sentence that says adoption of this resolution does not represent an individual member's agreement with the entirety of the contents of the submission or of the report.
Individuals what?
Member, not individuals, and individual members. Yeah. Stephen, go ahead with your language.
Consent to the entirety of the resolutions and recommendations contained in the report.
Resolutions, recommendations, and dissenting opinions, or is that obvious because those are signed on to?
Yeah, I think we can leave out the dissenting.
Okay. All right.
As much as I love omni, triumph, perfectum, and the rule of three, I would say we're good on those two. I figured if Justice Petcher could make, whether it was intentional or not, a Monty Python reference, I could get my Latin in there. What was I correct? Was
yes, you were. So can we just say, I'm always a fan of the simpler the word, the better. Can we just say an individual member's agreement?
Yes.
Rather than assent?
Yeah. My comments were a starting point, not necessarily the ending.
Okay, so I'm going to read this out loud. Adoption of this resolution does not represent an individual member's agreement to the entirety of the resolutions and recommendations included in the report.
Does that capture what you were trying to address, Ira?
Yeah, I'd make it a little simple. I'd just say individual members' agreement to the entirety of the report.
That's, you know what? That's
Yeah.
good. Thank you, Ira.
Can it be with instead of to?
Yeah, I think that's
yes.
right.
Yes. So adoption of this resolution does not represent an individual member's agreement with the entirety of the report. Good?
Yes.
Okay, and I'm seeing Ira in the affirmative and some other folks in the affirmative as well. So with that useful addition, is there someone who would like to move this resolution?
Stephen Hamilton, I move that we adopt this resolution.
And is there a
seconds it?
Was that you, Julia?
Yes, ma'am.
So yeah, sorry, I was talking over you, so I didn't hear it. All right, so great. So we have a first and we have a second. Do we have any additional discussion? I do not see any hands. So Linda, if you could please take the vote.
Bashan?
Yes.
Reynoldson?
Yes.
Falmouth?
Yes.
Fleischman?
Yes.
Hamilton?
Yes.
Judge Harper?
Yes.
Hartston?
Yes.
Kirkmeyer?
Yes.
McRae?
Yes.
Olvera?
Yes.
Robinson?
Yes. Expect next. So how to check back.
Judge Rubin?
Reach out to you if you need that. So that it's very
Hold on, we have some background noise going on.
you can, sign up.
Sorry, that was me.
Okay, sorry about that, but I'm gonna make sure that we get the vote quite clear. So Linda, who did you last have?
Judge Rubin?
Said yes.
Okay, Shining?
No.
Sarush?
Yes.
Spyro?
Yes.
Judge Wiley?
Yes.
And I think Judge Yu is still,
No, she's here.
oh,
I'm
she's here.
here,
Oh,
here.
Judge Yu.
It's a yes. Yes.
Okay,
Thank
thank
you.
you.
All right, and so
Carries.
and obviously
Thank
that carries, and I know that I don't have the privilege of voting, but I'm going to throw in my, completely ineffective and irrelevant vote for yes, just because I want to make it clear that I do believe that this accurately reflects all of the incredibly hard work that has been done by this working group. And I will be rereading this again, prior to presentation to the board, which is going to go forward on September 23rd. I do anticipate that we will have a meeting, which will be our true last meeting in December, to assist with the feedback regarding public comment and whether we think there should be changes made based upon such public comment. So that will get scheduled in due course. I don't know how I will survive 3+ months without seeing all of you on my screen, but I'll manage somehow. And I just cannot thank everyone enough, which I will do again in December. And also say that if anyone's ever in or around San Francisco and would like to say hi, I would love to meet some of you folks in person who I haven't had the privilege of meeting beforehand, and we can get together and have a cup of coffee and talk about anything and everything other than what the working group has been doing. That is my only criteria, that I would love to chat with all of you about something else. So with that understanding, please feel free to reach out. I hope everyone has a lovely weekend. Stephen?
I wanted to say something too.
We saved the state bar a considerable amount of money as a result of an unintended event, and that was the pandemic. We would have each been submitting reimbursement requests for our hotel rooms, travel time. We also probably spent 3 to 4 times more time working on this report than we would have, because those in-person meetings, 5 o'clock, you're going to wrap things up. We've scheduled so many more additional meetings at times. And I think all of us, especially those that have been involved since the beginning, probably put in at least 5 times more hours than we expected or anticipated when we were asked by our respective groups to meet. In light of that, and I don't think we're going to be able to meet immediately, there needs to be a meeting in person of this committee somewhere. Now, there happens to be a location proximate to one of the members that is equidistant from Los Angeles and San Francisco. So I'm just going to suggest it, that maybe that we have a meeting, a final meeting of the working group in Pismo Beach. I'd be happy to coordinate the efforts. We'll do it when we know that the next variant wave is over with. I will take responsibility for the planning, and I don't know that we can get reimbursement for it, but I'll figure something out. That's what I would say, because that's the one thing. We've all created relationships virtually for the most part. But I want to meet everybody. I want to have dinner with everybody. I want to have, a well-deserved glass of wine with everybody, because the work that we've done, notwithstanding our different positions and the interests of the different groups that we represent, is groundbreaking. What we have proposed, even the parts that I don't agree with, go far beyond the scope of any paraprofessional program anywhere. And I mean, even outside the United States. We've included subject matter that was not included in the Ontario program. We've included duties and scopes that are far beyond. So I think we've carried out our task admirably. And I think it's appropriate that we be able to celebrate that accomplishment appropriately. That was it.
I second the motion.
And Julia, you had your hand up. Was there anything else you wanted to say?
Yes, on behalf of the members of the group, I think in honor of Erica and Judge Yu, that we all say together, thank you, Linda.
Yeah, exactly.
Thank you, Linda.
And thanks, Christopher.
Oh yeah, thanks. Yes, thanks so much to everybody.
Everybody.
Leah, where did you go?
Stephen, you
There
were
are.
so eloquent. I just, I had the opportunity to work on many state bar committees, as you can imagine. This is the hardest working and most productive group I've ever seen. And you have really produced something incredible that's going forward to the board. So I thank all of you. And Julia, you stole what I really wanted to do, is embarrass Linda a little bit, because I think we saw there were 123 meetings that you all participated in, but Linda has participated in all of them, except maybe less than a handful, and written virtually, if not every memo, has had her hands in every memo that has come forward from every subcommittee. So I do want to embarrass her a little bit and really say thank you, and thank you to all of you. And Stephen, I would love to take you up on your offer. As you know, we are no longer a trade association. We can't have wine and cheese and swanky hotels anymore, but hopefully we can figure something out. And I really appreciate the sentiment. So thanks to all of you.
And thank you. Oh, sorry.
I just wanted to say, as part of the regulations committee, Linda, amazing, Leah, amazing. Also, Greg and Brady, you guys are also amazing. I was impressed each and every time. Like, how did they know so much? Right off the top of their heads. Oh my God, I got to prep 2 hours to participate on this. So thank you. I'm very grateful for your knowledge and experience. Thank you.
Thank you.
Absolutely. Well, there could not be too many things to go around, and clearly the final work product is a reflection of all of that. So I'm very happy to end one of our all-day meetings at about 1:30 in the afternoon. So have a wonderful rest of your Friday. Have a wonderful weekend, and see you all soon, and hopefully at some point in person. Thanks, everybody.
Bye.
Bye.
Everyone.
Thank you.